Welcome back to the second part of land law, leasehold covenants, and in this second segment, of course, we will continue what we started in the first segment. In the first segment, we started off by looking at the leasehold covenants and certain positions as it related to the landlord and the tenant. We did get to the point, though, in the last segment where we considered what happens when there is an absolute or a qualified covenant, and that's where we ended it. Well, what if the lease says nothing? So it does not say anything about a qualified covenant in respect of assigning or subletting, and it says nothing about an absolute covenant. Well, if the lease is silent on the matter, the tenant is entitled to assign, underlet, or part with possession without the landlord's consent. Again, I will pause here in relation to exam questions. You need to see what exactly the examiner says to you in relation to a particular assignment or sublet clause. Because if it says there's a covenant to that effect, of course it will apply. If there's nothing, the tenant, of course, can effectively do what he likes. Now, a covenant against assigning or subletting or parting with possession is often inserted in most leases. Although an assignment or sublet made in breach of covenant is valid, the breach will give rise to forfeiture or a claim for damages. We will, of course, explore forfeiture in the final segment of this session, but for now, just take on board that any sort of breach, of course, could give rise to forfeiture. With an absolute covenant, which it says that you cannot sublet or underlease, for example, the landlord is entitled to waive it, though he cannot be compelled to waive it, even if his attitude is completely unreasonable. However, with a qualified covenant, where prior consent is required for assignment or subletting, consent is not withheld unreasonably. Now, the way this type of question manifests itself on an exam is you get an exam question, and the exam question in the context of a leasehold question will say something like A leases Blackacre to B. The covenants are that B doesn't do one thing or another. The second covenant might very well be B does not sublet without the consent of A. Now, consider a couple of scenarios. The first is that B sublets without asking A. Well, we will get to that in a moment. But the fact that it says it would not be, or it can be sublet, but with consent of A, will mean that A cannot be unreasonable when B turns up and say to him, I have C who wishes to sublet, and he just says, no, I don't like C. That would arguably be unreasonable. Now, Section 19(1)A of the Landlord and Tenant Act 1927 says that T's option, if the landlord unreasonably withholds consent, is to either seek a declaration from the court that the landlord's refusal is unreasonable and that he's entitled to assign or sublet, or he could seek a remedy, possibly damages or an injunction, for the landlord's breach. Now, of course, the tenant could take a risk and assign or sublet without the consent of the landlord, but he would need to be aware that the landlord could bring an action for the breach of the covenant. Now, the onus is on the tenant to show that the withholding of consent was unreasonable. And the case of Ashworth Fraser Limited and Gloucester County Council says you're not entitled to refuse on the grounds which have nothing to do with the relationship of the landlord and tenant. So if, for example, the examiner tells you that the landlord has said to the tenant that he will not give his consent because the sublessee or the person to whom he wishes to assign is a foreign national, say, that will, of course, be unreasonable. Indeed, the question of reasonableness is one of fact, and the landlord will then be required to show that his conduct was reasonable, not that it was right or justified. So, let's say the landlord knows of the person who you're seeking to assign or sublet to, and he knows that he has, for example, a bad reputation for paying bills, for argument's sake, then that may not be justified because, of course, he's never had a relationship with that person for him to see how he pays his bills. But it may very well be reasonable, albeit unjustified. It is also unlawful to refuse on the grounds of sex, race, or disability in respect of the consent that the landlord is to give. Now, the covenant to repair, again, as a covenant which is likely to be expressed. With long leases, the tenant is usually the one who covenants to do all repairs. In short leases, the landlord frequently assumes liability for external and structural repairs, and in some cases is compelled to do so by the Landlord and Tenant Act of 1985 under the Section 11.1 provisions. Now, if no provision is made for repairs, neither party is liable for them. Now, the covenant to repair involves maintenance or replacement of parts or even complete rebuild if the property is destroyed. Now, a covenant to insure is normal for the tenant to covenant to do that, in that they will obtain and pay for buildings insurance for the full property value and for the full duration of the lease. The alternative is that a landlord will get the insurance but then charge the tenant for it. Of course, as between the parties, you may have what the parties call the usual covenants. What if the examiner says to you that the parties have considered between them the usual covenants? Well, if the parties have merely agreed that a lease containing the usual covenants shall be granted, or if there's an agreement that a lease be granted with the usual covenants, the lease must contain whatever covenants and conditions may be usual in the circumstances. And the general ones to include under the usual covenants, of course, is a covenant for quiet enjoyment by the landlord, and that he will not derogate from his grant. Also a covenant by the tenant to pay rent, and the tenant to pay rates and taxes. A covenant also by the tenant to keep the premises in repair and deliver them up at the end of the term. There's also the covenant to permit the landlord to enter and view the state of the premises if he is liable to repair. Now, here is an important one. When you see the term usual covenants, it is a condition for re-entry in favor of the landlord for non-payment of rent only, but not for breach of any other covenant. That is really very important because, again, it is a trick used by some examiners to say that the usual covenants are in place. The problem, of course, is that when we get to forfeiture, as I said in the final section, the point about forfeiture is that it doesn't normally engage unless there is an express covenant for forfeiture. But if you have the usual covenants do include forfeiture for non-payment of rent. So what the examiner will say, for example, is that there's the usual covenants. And then they buttress that by saying, for example, that the tenant is in arrears with his rents. And then, of course, they are leading you along a path which some students tend to follow, which is that you discuss just damages in that regard. But the point is, even though the examiner has not said there's an express forfeiture clause, the usual covenants do include forfeiture for non-payment of rent. There are other covenants which may be usual by virtue of, for example, local custom or trade usage. So if it is that in the particular area, you are allowed to rent with a shed on the land, for example, that may be considered usual in the context of the covenants. In each case, though, it is a question for the courts taking into account the nature of the premises, their situation, the purpose for which they are let, and the length of the term. Now, in the case of Flaxman and Corbett, it was put forward that a covenant would be regarded as usual if 9 out of 10 leases of the same kind would also include those terms. In a more recent case in Chester and Buckingham, the courts accepted a wider range of covenants in commercial leases, such as restrictions on, for example, alternation and a right of re-entry for the landlord in the case of any breach of the lease. Now, we will start on a particular area. Now, if you consider what I've looked at before, you're looking at the covenants, but what we're going to now turn to is a situation where there is a difference in relation to leases granted at a particular time. So there's one set of rules under the law for leases which are granted before the 1st of January 1996. And there's another set of rules, another set of legal rules, which deal with leases granted after January 1st, 1996. And it is important to the extent that it will tell you who will be liable for what. Now, that doesn't affect anything that we've discussed to date that is still relevant in any lease, regardless of when it was granted. What you need to consider when you're looking at leases in respect of the periods, it is whether or not certain covenants will apply, for example, to a sublessee or to an assignee, somebody to whom the lease has been assigned. So who is liable under a lease granted before the 1st of January 1996? Well, covenants are contracts which do place a burden on a covenantor or his land, and it gives the benefit to the covenantee of his land. A covenantor is the person who takes the covenant and is usually the leaseholder or the tenant. It depends on what the covenant is about. But the person who takes the covenant is or the benefit is the covenantor. The covenantee is the person who observes the covenant. Now, liability, as far as the covenantor and the covenantee, well, the covenantee tends, in most cases, to, of course, be the landlord. He's getting the benefit. The covenantor is the person with the burden. He's covenanting to do something. The original parties to the lease will always be liable. This is a pre-1996 position. The original parties to the lease will always be liable under the contract and will remain liable for the covenant for the entirety of the lease because of privity of contract. So even if they sell, assign, or transfer their interest in the lease, they will still be liable. It is known as the enduring privity of contract. Now, this was established in the case of Allied London Investment and Hambro Life Assurance. Now, even if the covenants are not expressed, and express consent is not given, an individual may be liable for implied covenants by virtue of Section 79 of the Law of Property Act, even after he has disposed of the property. Therefore, the original landlord and tenant will be liable for covenants under the lease for the full term the lease was granted for. Now, when the original landlord and tenant enter into a lease, the party will have privity of contract and privity of estate between them. Now, I want you to visualize, for example, a vertical line. And at the top, we will have L for landlord, and at the bottom, we have T for tenant. Well, the landlord and the tenant in that relationship have got privity of contract and privity of estate. When T assigns the lease to, for example, his first assignee, let's call that person A1 for assignee 1. For the remainder of the duration of the lease, privity of contract remains between L and T, that's the landlord and the tenant, as they entered into a contract with each other, but on the assignment, there will now be privity of estate between the landlord and assignee 1. Now, before we go into the break, I just want you to understand this visually. If you imagine the landlord at the top and the tenant at the bottom, and then if you imagine the tenant here and the assignee here forming a triangle, then as between the landlord and the tenant is privity of contract, as between the landlord and the assignee, we have privity of estate. After the break, we will of course continue in similar fashion, and we will see who is liable on the covenants.